An intellectual property strategy is a plan by a business entity to acquire and use intellectual property (IP) relevant to its business model. The intellectual property strategy is necessary to enable creation, protection, and exploitation of intellectual property. It is important for science granting councils (SGCS) to have institutional intellectual property strategies for various reasons. SGCS fund research and academic institutions through public funds. These research projects generate findings that may have intellectual property or assets. Some of the intellectual property assets so generated may have proprietary value now or in the future. Revenue from the commercialization could be reinvested into research and grow the national research and development kitty. While this requires a policy framework, in many countries this doesn't already exist. Collaborative research projects require that benefits from such research or innovation projects are accessed and/or shared by partners. In the absence of a policy framework to guide the commercialization of revenue from research projects and research collaborations, there have been cases where partners in such collaborations have disagreed, or some investors have taken advantage of the policy vacuum to exploit intellectual property without due recognition or acknowledgement or compensation to the intellectual property owners. The law relating to science granting councils and intellectual properties takes three main models, differing from country to country. In the first model, the law allows science granting councils to own intellectual property, meaning that intellectual property resulting from research funded by science granting councils in these countries belongs to the science granting councils. Science granting councils in such countries must work out mechanisms for ownership, licensing, assignment, and benefit sharing with other actors. The second model of regulation is where the science granting councils fund research and academic institutions, including individuals, but the research or academic organizations are allowed to own, license, and assign intellectual property. Under this model, research institutions and universities are allowed to own intellectual property from federally funded projects. They are also required to share proceeds of commercialization with inventors and to give exclusive licenses or to assign intellectual property. Universities and research organizations are required to avail information from non-commercialized intellectual property to other universities and research institutions on reasonable terms. Most importantly, universities and research institutions are allowed to keep proceeds from licenses and assignments and to plow it back to research. Academic and research institutions, therefore, have sufficient motivation for additional funding. The third model is a hybrid of the first two, where both science granting councils and the funded institutions are allowed to own, license, and assign intellectual property. This model is applicable where science granting councils fund and carry out research on their own. There are 6 main steps to setting up an intellectual property strategy. 1. Consider the nature of your organization and the model governing the science granting councils. 2. Establish guidelines for creating intellectual property. Such guidelines should cover 2 main areas: guidelines on optimizing searches on patent databases and for intellectual property registration. 3. Analyze and understand your competitive advantage and barriers to entry to enable channeling of resources only to those areas that are close to the organization's remit. 4. Analyze third-party interactions. Third party can include employees, suppliers, contractors, customers, partners, and potential infringers. Your intellectual property policy should clearly define these relationships and how to address issues such as employee contribution and recognition, labor mobility, succession planning, and continuity. For example, the use of non-disclosure agreements (NDA) helps to prevent leakage of vital research information. Any leakage of such documents can lead to loss of a competitive advantage. 5. Audit your intellectual property. The intellectual property policy should make provision for periodic intellectual property audits to identify and keep an inventory of intellectual properties and potential intellectual properties developed by the organization. An intellectual property audit should include a schedule of registered intellectual property including patents, trademarks, design registrations, and plant variety rights. 6. Consider where to protect your intellectual property. Different countries have different offices and registries for the protection of various intellectual properties. For example, there is a registry for copyright, a separate one for patents, industrial designs, utility models, and trademarks, geographical indications, and a separate registry for plant varieties. The law considers intellectual properties as private property, meaning that the owner must be proactive. Enforcement can be achieved through litigation, deterrence, and registration. An intellectual property strategy should also outline how to handle sponsored research with multiple actors including research funders and implementers of the research projects and address the following issues. A description of deliverables, clear definition of the project scope, payment, and funds management. Option to assign or license intellectual property. Assignment of intellectual property is the legal instrument for transferring, say a patent, from an inventor to a business. It is an agreement in which the inventor transfers all or part of their right, title, and interest in a patent or patent application to another entity. Licensing refers to the act of assigning the ownership of an intellectual property to a third party such that to make, use, and sell your invention either exclusively or non-exclusively for an amount of pre-decided royalties. Restrictions in the use of genetic resources or technology that has intellectual property. Ownership of intellectual property. Ownership of equipment purchased. Obligations relating to prior informed consent (PIC), mutually agreed terms (MAT), and material transfer agreements (MTA). Confidentiality of information. Protection of data collected during open calls for application for funding. Dispute resolution mechanism. There are 3 major steps that ought to be taken in the management of intellectual properties in institutions. 1. Set up an intellectual property policy to guide all matters of intellectual property. 2. Participatory development of intellectual property policy and intentional sensitization of the policy across all the institutions. Establishment of an intellectual property office to manage all forms of intellectual property with skilled personnel to handle intellectual property matters.